to this issue of Essential Environmental. I'm Thierry Montoya. Just a little bit about me, and so that you know why should you be listening to me. I've got 35 years of experience representing businesses, developers, and landowners in environmental litigation and the environmental compliance arena. And by that, I mean I represent buyers and sellers of commercial property that might be impaired by contaminant or contaminants and work them through that process. I represent businesses that are regulated by either the state, California's Regional Water Quality Control Board, or their releases of chemicals, and represent them in permit violations. I represent businesses, operating businesses, former businesses, current landowners, former landowners in federal and state contamination cases. And finally, I also represent parties in federal crimes for polluting waters of the United States. So, in my opinion, I have a broad array of experience, and I wanted to put on a podcast to kind of simplify this area of the law and walk people through concepts that they may come up with and explain them. You know, this podcast, of course, is I'm a partner with Alvarado Smith, and this podcast represents my opinions, the opinions of future guests. It's presented for informational purposes only. It's not intended for you to it's not intended to be construed or for you to rely upon what I say as general legal advice or solicitation of any type. But if you have questions and you want to follow up with me, I'll give you my contact information at the end. So, with all of that, today we're going to start with the concept of what is a phase one environmental site assessment, a term that's very common in the purchase and sale of commercial properties. And it's very important to know what a phase one consists of and what it doesn't cover, and also what kind of historic uses that a phase one might detect that may warrant an additional investigation known as a phase two. And a phase two is called a phase two because it follows a phase one. And of course, there could be a phase three, and you can go on as far as you want. But a phase one, as distinguished from a phase two, is a surface evaluation only and a records evaluation related to the property's historic usage. And it should always include, you should always pay for a site walk. You want your environmental consultant to walk the subject property that the buyer's client would like to purchase, because there's a lot of information that can be detected from a site walk. For instance, discolored soil, sumps in the ground, evidence that would suggest that maybe something has leaked there historically. A phase two is a subsurface investigation. So the concerns that are raised in a phase one trigger a phase two, or may trigger a phase two. And we'll talk about what, in my opinion, would trigger a phase two. May trigger a phase two, and so that would be putting soil borings, holes down to various layers of the soil, possibly down to groundwater. And in the case of, if it's suspected that soil vapors are in the soil and might permeate through the surface of the soil, come up through the surface of the soil as they do, you can put in soil vapor wells to determine what contaminants are in the soil and or groundwater, at what levels, at what depths, and how much of it is there. So that's the difference between the two. So let's transition back to a phase one. A phase one environmental site assessment, it's designed to identify what's known as recognized environmental concerns. And what that means is it's a historic evaluation of the property's uses as far back as the environmental consultant can go. I've been involved representing buyers on some commercial properties where they have evidence of the historic uses, going back close to the turn of the century. And they're looking for certain types of uses that would suggest the potential presence of contaminants on the property. Certain types of historic usage that would suggest the acquisition of chemicals that we now know are contaminants, the storage of such on the site, the potential release of such on the site. So that's what's recognized environmental concerns means. So types of historic commercial activities that would suggest the presence of recognized environmental concerns are, for instance, a historic industrial commercial use that involved solvent usage and waste production, a historic dry cleaning uses, especially dry cleaning uses prior to the 1990s, because prior to the 1990s, dry cleaning facilities used certain types of chlorinated solvents called, they're known by the anachronisms PCE and TCE, perchloroethylene and trichloroethylene. We're not going to have too many recitations of long chemical names, but you've probably heard about PCE and TCEs, and they were very effective at removing oil stains and grease. However, they've been listed as banned on the federal and state level, banned contaminants because they're gases. Molecularly, they're very heavy. They move easily through the soil and down to groundwater, and they are always what's known as off-gassing. They're always emitting their contaminating elements, organic elements up through the soil, can go through cement foundations, can go through asphalt caps. And what's emitted inside, if it's trapped inside a building, for instance, if it's emitting underneath a strip center, commercial center, an office building, those that work there aren't going to be smelling anything unusual. They're not going to be tasting anything unusual, but they're going to be exposed to PCE and TCE gases during the time that they're in the building. So they're contaminants of great concern over the last couple decades and going forward as well. Another recognized environmental condition that could come up are gasoline station usage. Gasoline stations have gasoline tanks that are buried under the ground, and they have dispenser systems. And, there are always some leaks involved. The gasoline station usage is a concern. It's become less of a concern in California because since the early 1980s, we've had the underground storage removal fund where gasoline station owners that need financial assistance to remove their gasoline tanks and replace them rather, with state-of-the-art fiberglass double-walled tanks with alarm systems that will shut off the tank and the dispenser system if a leak is detected. But there are still buried underground storage tanks that may not have been removed. So it's very important that a phase one environmental site assessment identify potential gasoline station usage, and then records can be reviewed to see if the tanks were ever replaced. And then there are underground storage tanks that who knows what they've contained. They vary in size, but those could be listed on a property. I have a client who has property in Orange County, and they purchased a property, and it had a 30-gallon tank, underground storage tank. We think that the former use was that of a cabinet shop, and it may have held some sort of solvents used as part of staining of wood, as part of cleaning wood, as part of the staining process, whatever it was. But that was identified and had to be removed. Now, we're talking about a phase one environmental site assessment that's performed as part of the buyer's due diligence period. It's part of the sale. So when we talk about due diligence, we're talking about the contractual period of time in the purchase and sale agreement where the prospective purchaser, the buyer, has the right to analyze all aspects of the property to try and identify any environmental risk, or if an environmental risk is identified, to request a due diligence period for phase two investigation if there isn't enough time, or if one isn't granted, to insist on a phase two investigation period. Essentially, the buyer wants to know that they're getting a property that isn't going to expose them to protracted cleanup period. Now, one of the legal benefits, aside from the contractual benefit of identifying your financial and environmental risks and identifying as part of the environmental due diligence in the purchase of property, whether you're paying for property at its marketable price as opposed to getting a deduction for impairment due to contamination or anything else. Other than those benefits, the phase one investigation has another very important benefit, and that is a legal benefit. So CERCLA is the federal cleanup statute where the EPA, the Environmental Protection Agency, can go after owners of properties, such as a buyer who buys a property and thinks there's nothing wrong with it, and it's later discovered to be contaminated. CERCLA stands for Comprehensive Environmental Response, Contamination, and Liability Act. And there are a lot of long titles in environmental law. So they're all shortened, thank goodness. So it's known as CERCLA. That was passed by Congress in the 1980s for the purposes of preventing contamination and release of toxic substances, and ensuring the cost of cleanup to be borne by responsible parties, and to deter future environmental releases. One of the responsible parties under CERCLA is the owner or former owner of the property. So if you're a buyer of commercial property and you're going through your environmental due diligence period, you want to ensure that you have a comprehensive phase one environmental site assessment performed, so that if later the EPA, or in California, its representative, the Department of Toxic Substances Control, contacts you and says, we believe that there's contaminants on this property and you as the owner are now responsible for cleanup, you can go back to your phase one environmental site assessment report and say, we purchased this property and the environmental site assessment did not detect any recognized environmental condition, nor would we have known about the environmental site condition that you're now bringing up. So that would be a defense to CERCLA liability. CERCLA liability is brutal because it is joint and several, and it's strict liability, cradle to grave liability. So what all that means is, if you're the owner on title of property that the government now thinks is contaminated and is pursuing you or your corporate entity under CERCLA, there may be other parties that are responsible, but the government can say, no, we're focusing on you. You're the current owner. If you want to bring in other people to defray your expenses, you can, but it's joint and several liability. So we're just going to go after you. And it's strict liability, which means you can't say, I didn't mean to do anything wrong. I didn't do this. It was done by a business in the chain of title. No intent is required under strict liability. You just have to clean it up. So you can qualify for what's known as the innocent landowner defense to any future CERCLA liability if you as the buyer had no knowledge of hazardous substances on the property, and you as the buyer, as part of your contractual due diligence, conducted what's known as all appropriate inquiry into the previous ownership and uses of the property. That's quoted from the CERCLA statute. So to qualify for the innocent purchaser defense, you as the buyer must have performed a phase 1 environmental site assessment that meets the all appropriate inquiry legal standard as set by the EPA. So there's a lot riding on the phase 1 environmental site assessment, and you never go cheap on a phase 1 environmental site assessment. We'll talk about my recommendations on what kind of environmental site assessment firm you should retain. But you've got a lot riding on it. You've got a lot riding on it from the standpoint of paying too much for the property, for buying property that could then expose you to legal liability, legal cleanup liability to a government entity, and leaving you with no defense. So let's transition now to what are the components of a phase 1 environmental site assessment. It consists of what I mentioned before, a site visit. You have to have someone walk the site, boots on the ground. They got to look for evidence of former chemical storage areas. And if you have a good environmental site consultant, they would get a sense for what that looks like. I have had environmental site assessments where their former usage involved automotive repair facilities, former dealerships, and there you want to make sure your environmental site assessment folks walk the property looking for evidence of where the hydraulic jacks would be to lift vehicles so they can work underneath the car, because those hydraulic fluids can leak over time, and those have components that are listed as contaminants. So site visit is very, very important. You want your phase 1 contractor to conduct interviews with current and former site owners and have them go back as far as they can to talk to all of the historic owners of the property where there was a commercial use of, that might suggest a recognized environmental condition. They should also conduct interviews with state, local agency officials. They should be looking at publicly accessible online databases in the form of, in California, you have the Regional Water Quality Control Board that has a site, geo-tracker, where you can put in the address and it will indicate any businesses, areas in which are under investigation, including subject property or adjacent sites. And then it becomes relevant as to how close the site is to yours, because it's entirely possible that contamination from an offsite source may have drifted onto your property that you're interested in purchasing. You're not responsible for contaminants that have come your way, but you would have a cause of action potentially against the party that released the contaminants that are drifting towards yours, if that entity or owner or owners are still viable, if they're still around and they still have money. So you want to know about actions taken by the Department of Toxic Substances Control. Their publicly available site is Environ, and the Regional Water Quality Control Board, to make sure that nothing is detected on your site or in a vicinity close enough to where it may drift. Phase one environmental site assessment is structured to identify, we talked about recognized environmental conditions. We talked about prior uses that would suggest potentially the presence of contamination on the site, or recognized environmental conditions in the immediate vicinity that may warrant conducting phase two investigations to make sure that no contamination from offsite has drifted on site. But they also, phase one environmental site assessment also looks for historic recognized environmental conditions. I represent buyers and sellers of property where the property was the subject of a former cleanup, but it has been cleaned up to the government entity's satisfaction. So in those cases, what you would have, and never lose this if you're the owner of the property, you would have what's known as a no further action letter from the government agency that supervised the remediation and called it quits when the remediation goals were met. No further action letter means that the party has cleaned up the property to the satisfaction of the governmental entity. A no further action letter is not in monopoly get out of jail card free for the future, because if there are any further releases, or if there's any contaminant releases that are different than what was the subject of the prior cleanup, they don't fall under the protection of a no further action letter. So phase one environmental site assessments look for evidence of historic environmental conditions and track down whether cleanup action was done to the regulatory agency's concern and it's, at no further action status. The last category, phase one environmental site assessment, also is structured to identify what's known as controlled recognized environmental conditions. And what that means is, again, there were in property's history some releases of contamination that have contaminated the soil and or groundwater, but there are corrective measures in place such that as long as those corrective measures remain operational, the property's use is not hampered. What do I mean by that? So I come across clients that are cleaning up their property and getting a closure status from the government, but closure is based on putting in a thick rubber membrane over the top of the contaminated soil, and then the building would go on top of the thick rubber membrane to prevent any future release of gases from the soil up through the building foundation and into the building. So the membrane is kind of like a thick rubber plunger, if you want to think of it that way. Controlled recognized environmental conditions relate to the property has been cleaned up to the satisfaction of the government in terms of its use, its properly zoned use, residential, commercial, mixed use, whatever it happens to be, can go forward, but with these guarantees in place, like you want to put an apartment complex on the property over that area of soil where soil gases may still be emitting at much less frequencies than before, then you'll have to put a membrane in between the soil and the building. In that case, you may also have to continue to operate for, as many years as the report identifies, soil vapor wells to suck out soil gases from the soil and release them through the air without any human harm. And or you may also have operating groundwater cleanup wells. So If a phase one environmental site assessment for the property of interest to a buyer identifies a controlled, recognized environmental conditions, it is important to know from the buyer standpoint, it's important to know how long do I have to allow those conditions to remain in place? Could be in perpetuity in terms of a membrane. And it's important to know the limitations. And that is, if you do some excavation on the property in which there's a membrane and you tear into the membrane, breach the membrane, then those controlled environmental conditions say that you have violated your obligations to the government, and the government can start a whole new action against you, the buyer, for disturbing the membrane. Or if you turn off soil vapor wells, or you decide, I don't want to have to deal with these groundwater extraction and cleanup systems on my property over there for whatever reason, and you remove them or turn them off, then you would immediately expose yourself to environmental contamination liability. So there you have it. The goal of a phase one environmental site assessment is structured to identify those types of environmental conditions. Now, one of the other aspects of maintaining the all appropriate inquiries standard and the innocent purchaser defense in terms of, if you're a buyer and you want to conduct environmental site assessment, you must have a full and complete phase one investigation performed that meets the all appropriate inquiry standard, which we've talked about here: site visits, government reviews, identification of all types of environmental conditions. But here's the one that always tends to trip up buyers, and they lose their defense. You have to make sure that you have phase one that is reviewed again by your consultant to make sure there's no loose ends, there's no additional former owner that they identified but couldn't make contact with and should have interviewed. Make sure that there's no additional agency databases that they should have reviewed. Make sure that they've tied up all the loose ends in the report that they say they're going to tie up within a year of the purchase date. So it's very important to have someone skilled at reading phase one environmental site assessments that can tell the buyer client that, all right, the environmental conditions were identified. They're not really going to be much of an issue, but I see here that the phase one consultant is recommending that we do this additional work and that we consult with a former owner. Might cost you a little bit more money, but it's important to maintain that innocent purchaser defense and make sure that the phase one environmental site consultant completes all of those conditions within a year of the purchase date. If there's no environmental conditions that are identified in the phase one report, and the phase one report does not say, we would like authorization to look into this area, to consider this, everything has been nailed down and there's nothing more to do, then you're fine. Enjoy the property. But if there are recognized environmental conditions present at the site, then you have consideration as a buyer as to what those conditions are and whether they warrant a phase two environmental site assessment. There are certain, in my opinion, and I represent buyers all the time, including last week when a buyer contacted me and said they were interested in purchasing a property. It was a strip mall, and historically there was a dry cleaner in the property, and the seller's consultant did identify PCE and TCE in a soil boring that they dug down to 40 or 50 feet below the surface. But the consultant didn't think it was going to be a problem because in the consultant's opinion, the PCE and the TCE detected at that depth was too deep for it to come back and off gas through the surface. I would take exception to that. I think that in the case of a recognized environmental condition that suggests metals processing business historically on the chain of title, dry cleaner historically on the chain of title, any business that's involved in degreasing of metals, metals processing, forming of metals. Those metals have to be degreased before they're bent and shaped and heated. And, whatever the process is, all of that suggests potentially the historic use of degreasing products, which would suggest PCE and TCE. If you have PCE and TCE, in my opinion, you're going to want to seriously discuss with a consultant a scope of work involving phase 2 site assessment in terms of detecting whether there's PCE gases in the shallow layers of the soil. So soil vapor wells can get that information, or, depending on where the groundwater, the level of groundwater is in that area, could the PCE have gone down to groundwater? Treating soils, or actually a better way to put it is remediating for PCE and TCE in soils can be an exceedingly costly endeavor. It can involve years of working with regulators and many hundreds of thousands of dollars pretty quickly. Gases can move easily through the soil, as I mentioned before, and they can get trapped and accumulate in great pools underneath footings, foundations. And so, you could be putting a lot of soil vapor wells into the ground. You could be putting a lot of borings into the ground to try and kind of pinpoint the pool of gases. And I've had cases where clients have really had to just scrape a building down and remove the foundation to relieve the major pool of gases that are pressurized under foundations. So it's a very costly and risky process getting involved in a property that has PCE and TCE on site or drifting to the site. It's important also for a buyer to recognize that phase 1s don't identify, and they're not required to identify. So if mold is of issue to you, asbestos, radon, lead, or wetlands are of concern given the property's location, you're going to want to pay for those additional scopes of work. Again, you want to know if the property has any warts and whether you want to buy it. And if you still want to buy it, are you paying too much for it? And you want to qualify for the CERCLA innocent purchaser landowner defense. We talked about phase 2 investigations. Phase 2 investigations, would be very strategic. I get involved in interpreting phase 1 environmental site assessment reports or buyers in terms of, is there any concern here? And then making recommendations for whether a phase 2 investigation should be performed or not. And then I refer buyer clients to phase 2 environmental geology, environmental remediation firms that are very strategic thinking, because you just don't want people poking holes around your property just because that generates decent income. There's an art to it and there's a science to it in terms of where they think the source of the we'll just use PCE or TCE contamination as an example, where they think the source of the gases may be, where they may be drifting to, and that would suggest, some strategic placement of soil vapor wells to identify, hopefully, the greatest concentration of PCE gases and its path of movement. And if that could be done as part of the environmental due diligence period, you may be able to have information as to whether you're going to be able to deal with that as part of the transaction and possibly a discount, or whether there's so much gases identified beneath the soil that you should find another property to invest your money in. It's a big area of concern for me because I'll give you an example. I have a current client, not identifying names, or the properties in the Los Angeles area. They purchased a mixed-use commercial development, great price. After purchasing it, a downstream boring identified extensive levels of PCE gases at shallow depths, and by that I mean 5 to 10 feet below the surface, coming from my client's property. So, with that detection, there's an obligation to identify the regulatory agency. In this case, it's the Regional Water Quality Control Board of soil contamination, and potentially then you embark on a whole strategic sampling all around the property to identify the extent of the PCE and TCE contamination from a horizontal standpoint and from a vertical depth standpoint. There was they got involved in this property because they didn't do any phase one site assessment. Had they done a competent phase one site assessment, they would have historical records would have suggested a major, significant, very large dry cleaning business in the building right next to theirs that historically was a dry cleaning business that would take in clothes from other dry cleaners and clean them. So, it wasn't what you would think of as normal neighborhood dry cleaning business. It was kind of on a wholesale basis. That dry cleaning business went out of business in the 70s, and there are significant levels of PC and TCE gases that were released into the soil by that business, traveling down to my client's property using sewer pipes, old depressions in the ground, because gases can easily move up, down, sideways, and has my client involved in what's going to be a very, very lengthy and protracted cleanup case, to include my having to sue the now current owners of the adjacent property because they're on hook for cleaning the site. So, in my opinion, anytime there's a history of a business or usage that would suggest chlorinated solvents on site, or metal degreasing, or metals processing, those are businesses that it's always been very difficult to run in a very clean, non-release of contaminants manner. So that's something that has to be followed up in terms of a phase two. It's a question of what type of phase two. And in those situations, if a seller is not willing to allow a phase two, I am of the opinion that's a red flag there. I think the seller knows that the property might be compromised and is trying to pass it off on someone else. That's a red flag. As an alternative, the buyer, if they still want to take on the contamination risk, they may want to cancel the contract to renegotiate the price, some additional due diligence terms to request a strategic phase two investigation so they know what their risk is going to be. And again, if the buyer's not interested in that, you may want to consider walking from that property and finding something else. Petroleum contaminants in the terms of former gas station usage, that's also of concern. If there was a gasoline station on site and there isn't evidence the tanks were removed, you may want to consider a phase two investigation involving the use of surface radar to see if it detects an underground storage tank beneath the surface, or whether the radar does not detect a storage tank. Petroleum hydrocarbons are, if you think of oil, they're thick and gooey. They congeal together. They can move around in groundwater, but they don't move that readily through the soil. So it would be possible. I've had cases where some petroleum hydrocarbon was detected in the soil going back, a couple decades or so, but it's so deep beneath the surface of the ground that a regulatory agency would allow it to remain in place. It's important to note that in my world, soil and groundwater contamination, I can't think of an instance where I've dealt with a property where all of the contamination was removed, where the property, in other words, was rendered clean. There's always some contamination that's allowed to remain. You just have a consultant conduct an additional study to make sure that what is left does not pose human and health safety risks that are, out of order in terms of magnitude. So it's not unusual to find some contamination in the ground, and depending on the type of contamination, like maybe some levels of metal contamination or petroleum contamination that's rather heavy and stable and kind of stays there and it's deep enough, may be able to get by with just leaving it in place, or potentially drilling a few holes and putting in some biological products that will eat the contamination. So I like to end with kind of a call to action there. And the call of action is, as we've discussed, it's critically important for a buyer of commercial property to get a phase one environmental site assessment. Do not go cheap on it, and pay for all the necessary components. Follow up with the contractor and make sure that no loose ends are allowed to remain. And my call to action there are firms, very competent firms, that perform phase two site assessments. They know what they're looking for. They know what levels of contamination are acceptable. They know what types of contaminants are going to be doing. They understand the concept of contaminants moving through soil, off-gassing. Those are the kinds of firms, if you suspect that you're interested in a property that had a dry cleaner or sort of metals processing history, I would recommend that you don't go with firms that strictly provide phase one environmental site assessments. And, if you look at 20 of their reports or 40 of their reports, they tend to have the standard language in many sections. You want to go with someone who's going to know what the contamination looks like, evidence of surface contamination, evidence of subsurface contamination when they're walking on a site, and they're going to know how to quantify your risks with a strategic phase two assessment if need be. A phase one environmental site assessment from those types of firms is probably going to be more expensive than firms that just perform nothing but phase one site assessments. But you don't want to penny pinch and get involved in a subsequent cleanup action. Don't want to penny pinch at the expense of the innocent purchaser's defense. If recognized environmental conditions are identified, I help buyers that are interested in proceeding with the sale negotiate environmental indemnifications, hold harmless agreements where the seller holds the buyer harmless or pre-existing liabilities. That may involve the seller taking responsibility with a regulatory agency for any future cleanup. That may involve quantifying what a cleanup would look like with an environmental consultant and coming up with a holdback amount that the buyer puts in escrow for the buyer to use for any cleanup. Lots of different ways it can be fashioned, but the buyer should seek protection if from the seller, and favorable indemnification language just on environmental grounds alone if recognized environmental conditions are identified and it's still a property of interest. There's also, I also get involved in these kinds of areas to see if there's insurance, environmental insurance that could provide coverage for the recognized environmental conditions, pollution liability coverage, cleanup, cost cap coverage, which means you're buying a policy where an insurance company agrees to clean up to a certain dollar amount. They could provide the buyer some risk mitigation. So thank you for listening. I hope you found this useful. Phase one site assessments are critical for a buyer, and they have to be done correctly. And I assist buyers all the times in these matters on the issues that we discussed. Our next podcast is going to discuss the issue of, if you know the property is contaminated and you want to purchase it, how do you maintain the other defense to CERCLA, the bona fide prospective purchaser defense to any future liability? Because you can buy a contaminated property, what's known commonly as a brownfield, and you can get a defense to future environmental liability, but there's some tricky aspects to it, and we'll talk about that. If you have any questions, you can reach me via email at tmontoya Alvarado Smith, or via my phone, 714-852-6862. Thank you for listening.